Good afternoon, and thank you for attending today's presentation. I'm David Sterling. I'm the CEO of SterlingRisk. Abuse and molestation exposures represent a growing threat to the non-for-profit sector. During today's webinar, you're going to hear from a panel of leading experts on how your organization can prevent and investigate and ultimately defend incidents or allegations of abuse or molestation. We are very pleased today to be joined by our excellent panel. Aaron Lundberg is the president and CEO of Presidium, one of the premier consulting companies in the field of abuse prevention and investigation. Mr. Lundberg has assessed, analyzed, consulted on hundreds of cases of sexual abuse with a wide range of organizations, including community centers, schools, residential treatment centers, camps, and recreation facilities. He's trained thousands of administrators, CEOs, board of directors on their role in preventing the sexual abuse of children and vulnerable adults. Mercedes Colwin and Misty Maris are senior partners in the national law firm of Gordon Reese. They have collectively defended thousands of lawsuits throughout the country and won over 90% of their numerous trials and arbitrations. Both regularly litigate business disputes to defend corporations and executives of Fortune 500 companies accused of wrongdoing, including claims of sexual misconduct. Mercedes and Misty regularly appear on television. You might have seen them on CNN, MSNBC, and Fox News to discuss critical legal issues affecting the nation. We are particularly proud of the SterlingRisk panelists, Josh Weisberg and Susan Warhurst. Josh is Sterling's chief claim officer and oversees their risk management services department. He's an insurance litigation attorney with over 20 years experience handling coverage disputes and policy drafting matters for a full spectrum of clients. These include policyholders, insurance carriers, brokers, and managing general agents. Susan Warhurst, our senior vice president and commercial lines director, brings over 35 years of insurance experience and risk management experience to her clients at Sterling. She and her team specialize in social service space and have developed extensive relationships with insurance carriers and risk management partners in the industry. She partners with them in the placement of liability insurance and for a complex range of diverse coverages in the not-for-profit space. Once again, I want to thank you so much for joining us today. We have set aside some time for questions, and I encourage you to feel free to type them into the comments bar, but you can, of course, reach out to any of our panelists after the presentation concludes. Thank you, and please enjoy.
Thank you, David. We appreciate the introduction and truly look forward to speaking to all of you on this important topic. As you mentioned, on the next slide, you will see that we're going to cover four main areas. And so first, we will all talk about a little bit of the scope of the problem and what we can do to prevent abuse or molestation claims to begin with, because that's everyone's primary goal. The second thing we're going to talk about is if there is an incident within our organization, things that we can do to mitigate the effects of that, both first and foremost to our consumers, our children, or vulnerable adults, as well as to our organization and our mission within our organization, and how we can defend any claims that may be brought against us. And then last but not least, Josh and his team are going to be speaking towards the state of the market with abuse and molestation coverage, and talking about how to structure the coverage to best make sure that it protects you and your organization. And so let's jump right in. The next slide, actually we can go 2 slides. We're going to talk a little bit about the scope of the problem. And so first and foremost, to kind of set a framework, what we know is this issue happens way much more than we would like. And so whether we're serving children or vulnerable adults, the statistics are troubling. And so in regards to children, it's estimated that 1 in 4 girls and 1 in 13 boys will be sexually abused before they turn the age of 18. We also look at the statistics and the problem and the scope of adults that we serve, whether it's in behavioral health, addiction treatment, nursing homes, anywhere a vulnerable population is served. And what we know is adults with intellectual disabilities are 7 times higher to be abused. Elderly are 3 times higher to experience abuse. We work a lot within the medical arena, and research is not widely known, but there's very, very significant cases just within the medical health. So we are all in a position to be able to protect the consumers and to make sure that we're doing everything we can to prevent these incidents from happening. We're not going to get into it throughout the presentation, but I do want to make note that we're really talking about 2 different types of incidents. And so one is adult to consumer. So that's anybody who is in charge of protection or in the care, custody, of control of another person. So that could be a camp counselor and a camper. It could be a lifeguard who's overseeing aquatics. And so it could be in a lot of different contexts where that can occur. But we're also talking about client-to-client abuse. And so that's where one client abuses another client. So you'll see some statistics on that a little bit later. And then last but not least, while these statistics are troubling, what we also know is that estimates are that 80% of all abuse goes unreported. And when it does go reported, the most likely age, the median age of a victim reporting is in their 50s, 52 years old. And so there are a lot of barriers for people in the present day, if they're being abused, to report that abuse. And even as they get older and they get out of that abusive relationship, the average age is until their adulthood, until they actually report. So that's our primary focus, of course, is we want to protect the consumers, but we also want to protect our organization. And so any way you look at it, this risk is one of the biggest risks to your reputations. And so we all know of the organizations who have had numerous cases in the news and what that's done to their reputation, to their mission, and so forth. And we also know that this is one of your most expensive risks. And so we, Presidium, do an analysis every 5 years and look at verdicts of sexual misconduct cases. And so these are cases that actually go to court and what the verdicts are when they go to court. And so what you see is if they actually go to court, the vast majority of the time they will lose or the plaintiffs will win. And so that's about a 42-to-8 ratio. So out of 50 cases, you can see the win-loss ratio on that. Now, that is a reason why most of these cases do not go to court and they get settled. And then when they do, you can see the range of damages. And so the range from this analysis was 15,000 to 60 million. As you can see, this is a little bit out of date because we've all heard of the extraordinary payouts, both settlements and verdicts in the last couple of years, hundreds of millions to billions of dollars. The average payout's around 7 million. And then when you do an analysis of youth versus adults in terms of who the offenders are, 30% are youth offenders and 70% are adult offenders. This is significant because historically that number has been more of a 90-10 split. And as we see time goes by, we see more litigation involved in the client-to-client issues that I was talking about. And so we're seeing those cases being litigated much more frequently. And then the last piece I want to point out is when you look at where the organizations were found at fault, they break down in this way, and I'll summarize it a little clearer than this graph. And so first, you can look at the supervision of clients or staff. And so the vast majority of cases that occur, they get held liable for negligent supervision. The second is negligent retention. And then I'm going to also group in what you see here is negligent investigation. And so 44% of the cases, the organization was found at fault for how they responded, right? Basically. And so we're going to talk about that in a little bit. And then The last piece I'll hit on is the negligent hiring. And so that's what do we do prior to someone becoming an agent of our organization, their employees or volunteers, to give access to our vulnerable populations, to screen them out to begin with. And so we'll go to the next slide, and we're going to talk about some of the things that we can do to manage those. And so Presidium works off of our safety equation. And so what the next slide shows is that while those statistics are troubling, the good news is that this is a preventable risk. This is not a risk that we have no control over. And if it happens, we can just respond really well. And so there are those types of risks out there. And so I live, and our office is in Dallas-Fort Worth area. And every spring, every fall, we have tornadoes, and they come through Fort Worth and through Dallas. And there's nothing that we can do to prevent those tornadoes from coming in and causing destruction. However, what we can do is once a tornado has been alerted to, we can respond well to minimize the effects, right? And so fortunately, this isn't one of those risks. And so based on our analysis of over close to 5,000 cases, what we find is there's not 5,000 reasons these cases are happening. That would be an unpreventable risk. And unfortunately, there's not a silver bullet either. And so unfortunately, there's not one thing that we can do to prevent all the cases that occur. Instead, what we find is there are 8 different root causes to these cases. And so that's what you see before you. The Presidium safety equation is made up of 8 different operations, the 8 root causes of incidents that will either contribute to a case happening if we don't have the right safety protocols in place, or help us prevent abuse. And so we have best practice standards under each of these 8 operations that we help organizations manage the risk of these kinds of cases from occurring. But it's important to note, most of you on this call, on this webinar, come from a variety of different industries. And how one industry manages this risk is much different than how another industry manages this risk. There's not 10 things that every industry can do, and that's going to cover them sufficiently. And so instead, how the safety equation works is based on what you do and how you do it, you will get points in some areas and lose points in another area. But the goal is to get 100 points. And so, for example, if you're a mentoring organization, you automatically lose a lot of points in monitoring and supervision, because the nature of mentoring is one-on-one interactions, and you can't change that. You don't want to change that. That's where the difference happens. However, because mentoring organizations lose points in monitoring and supervision, they have to increase safety points in places like screening and selection. So a mentor is screened to a higher level than a childcare worker who is always working around other people from certain hours. And so it's very much more controlled. And so every industry will gain points in some areas and lose points in another. And so based on what you do and how you do it, you can use this paradigm to learn kind of where your industry standards are and how you can make up some safety points based on your industry and also the culture that you all operate in. But so we're not leaving it so theoretical. Every industry should be looking at doing 5 core things that meet the industry standards that have been set, that meets the areas of liability that we showed before. And so here are 5 areas that if we were working with any client, we would have them focus on. And so the first is to implement standardized policies, in particular for boundaries. And so if you are a behavioral health organization and you're serving adults who are in treatment, one of the key issues you have here is you have your employees who are serving them, maybe the same age, can actually be much more of a peer to that individual than a 40-year-old who is working in a school of a 5-year-old, so first grade, second grade. It's a lot harder to cross boundaries when there's that big a gap. It's a lot easier when there's less of a gap. And so we want very, very clear policies to guide those boundaries. The next is we want to be able to screen for abuse risk. Background checks are essential. However, they're insufficient. Less than 5% of offenders have criminal histories. However, background screening is an industry standard, and you want to make sure not only you're doing a background check, but you're doing the right type of background check. And so not every background check is created equal. And so you want to make sure that your background screening is comprehensive. Next is training. We want to make sure that people are trained not just on reporting, but actually prevention. Again, this is a preventable risk. And if all that we do is train people on how to report warning signs that abuse is happening, we're treating it as an unpreventable risk that we can just respond really well to. The next is monitoring and supervision. And last but not least, that we'll talk about here in a little bit, is responding and investigations. And then those are all the things that an organization needs to do. However, without the right culture to support those things, that's not enough. And so what we see with our organizations is we can tell them all the right things to do and they can implement all the great things, but if they don't have the correct culture to keep those things intact and make sure that everyone's living out all of those safety practices day in, day out, then they die over time. And so what you see before you is actually based on a lot of literature and research that's been done on HROs, highly reliable organizations like aircraft carriers, hospital systems, nuclear power plants. And what they find is all of those different entities have different things they have to do to manage risk, and they're very different from one another. However, when they do their analysis, there are certain cultural aspects across those places that they have absolutely in common. And so that's some of the characteristics that you see here. So that's the big picture on prevention. And next, we want to talk about we can do an awful lot to prevent these cases. However, there's two dynamics. Is one, we can still have those occur. And so we want to minimize to the extent that we can incidents, but we still might have things that occur outside of our control. And then second, some of these incidents didn't happen on our watch. They're historical in nature. They happened 20, 30, 40 years ago. So the things that we're doing now can't prevent what happened 30, 40 years ago. And so we have to be in a position where we can respond really well to these cases to do the best in the best interest of the victims and survivors, as well as our organization. And so this is a paradigm that we can talk about more at the end if we have time. But essentially, the picture we want to paint here is if all that we do is follow our licensing requirements or follow mandated reporting laws, that puts us square in the middle of this diagram, puts us in a compliance mindset. And while that may be sufficient for meeting those requirements, whether it's a reporting procedure, we have to call the police, whatever it may be, that does not do enough to respond in a way that's in the best interest of the survivors or in the best interest of our organization. And so we have to be in a commitment mindset. We're doing the right things the right way that are oftentimes scary and feel like you're putting yourself out there to be exposed to liability. But based on research, based on 30 years and thousands of cases of review, what we know is it's just the opposite. And so we'll go to the next slide. And so I'm going to start with kind of three overarching themes. And then, we can talk a little bit more about the actual investigations of it as well. But essentially, what we have found is when there's a horrific incident of abuse within an organization, it's just natural for that organization to want to have a closed system in response to that incident versus an open system. And so we have done a lot of research, and it's outside of the abuse prevention world. And actually, we just released a white paper last week that heavily cites a lot of healthcare. There's been a lot of research to this in healthcare, that the more open you are in your response, you're going to help the survivor heal. And then B, you're going to reduce the risk of any kind of liability and judgment on your end. And so basically you can break it into three things. Is one, when you respond, be compassionate. And so compassion means just being human and showing your emotion and saying you're sorry. And compassion oftentimes means saying, how can I help you now? And so it's become standard practice to offer counseling services to survivors. If they were abused 30, 40 years ago, to say, hey, can we offer you counseling services and pay for those counseling services or whatever they might need. The second is transparency. Stay in communication as much as possible with your community and the families, and provide as much information as you can. You can't be 100% transparent oftentimes for certain reasons, but there is a level of information usually you can share. And the last, be competent. You all have a great organization. You all have great things in place, especially if it's a historical allegation. That's not how the program you operate now. And so you want to reassure your community with the confidence for that response. And then I know the audience we have today is very in tune with their reporting laws, and this kind of goes without saying, but if in doubt, we have to report. And so if you find your organization in a bit of a debate of whether this is reportable or not, the fact that you're having that debate, it should be an indication that we're going to err on the side of safety and go ahead and report this to the authorities and follow our mandated reporting procedures. Last but not least, this topic is moving fast. And so it's hard to go a day without seeing some big expose in the media. Currently, it's been USA Safe Sport. You've seen that with USA Equestrian, USA Gymnastics, and so on and so forth. And so industry standards are moving very, very quickly, and we track them, we benchmark them. And you kind of see the line looks kind of steady going up, and then all of a sudden, you're seeing organizations being held accountable for more. Organizations are relying more on data and analytics in regards to how these incidents are happening. It's becoming standard practice to have a victim-centered response, and transparency is being demanded from organizations. And so that doesn't just mean as a result of an incident, but it also means, what are you doing to protect consumers? And so organizations are putting on their website now, here's what we do to prevent any kind of abuse or any kind of harm to our consumers. And here's who you can call in our organization if you have a question or want to report. And so there's a lot of things that organizations are being asked of to do today that they weren't doing yesterday. And organizations as a whole are rising to the challenge to the most part. You can see organizations just over the last 3 or 4 years who have really stepped up their efforts to protect their consumers as they learn more through this journey.
Well, certainly defending claims, and a huge thank you to you, Josh, and to Sterling. This is such a privilege. This is Mercedes Cohen, Misty Maris, my colleague and partner at the firm. It's a real privilege to be here today and to talk about a topic that has really captivated headline news. And it's no wonder that's our very first part of our topic, the headline news. And it's exactly right. As Aaron said, these are crippling allegations that can take down companies, corporations, nonprofits. And we've seen it time and time again. An example of that just recently, Boy Scouts of America, we did some research in preparation for today. In social media alone, the allegations against Boy Scouts of America, obviously many of you know that there were about 82,000 members of that class. There were 338,000 hits on social media alone. That doesn't capture the television. It doesn't capture any other forms of media, the print media, the blogs, all of that. Just those hits alone on social media, that was obviously extreme. And looking at the recovery for right now, it's in bankruptcy court, as many of you know, that crippled the organization to such an extent. They needed to file bankruptcy court. All those allegations and that class action is now moving its way through the bankruptcy courts. But so far, their fund is about $2.7 billion, to what Aaron had mentioned before, that the recovery can be pretty extreme. Now, the litigation rules of engagement, very different. It's not like any other type of case, because really at the core of it, many times these allegations or decades ago. That's where the Child Victims Act come in, and there are other legislation that Misty's going to walk through that's pending, where their adult victims can actually come forward. And that's also pending right now. We presume it's going to be legislated and brought into law shortly. But why do I say that these types of cases are different? They're different because there are credibility issues. Witnesses have to be found. Documents may not exist. Standards are different. The standards that took place decades ago, very different than the standards they are today. But what happens to entities that are brought with these allegations present day? It's present day standards that are upheld repeatedly in court. So experts are really one key way that we look to defend these types of claims. One expert that Misty and I use very regularly are what's called the false memory syndromes. These are brought in cases where there are adults alleging victimization as children decades ago. And all of those challenges start to stem through. The challenge of the witnesses, the documents, investigation. Many times we can't be found, but an expert can take that individual medical examination of the claimant and start to develop a narrative, which will defend those types of claims. We are then faced with other types of experts. The experts at the plaintiff's bar, they look for the memory recall experts. Those are how they try to defeat the false memory syndrome expert that we use.
Yeah, and just a practice tip, it's so important because most of the experts that we see in this field in New York and even across the country, you see the same names over and over again. In the medical community, the false memory idea has been something that's largely debated, false memories versus repressed memories. So just from a practical tip point of view, it's really important to dig deep, find papers that these experts have written, go back, find testimony, because we've had great success impeaching some of these experts with their own words on the veracity of these false memory and repressed memory claims. So make sure that you're asking, or if attorneys are listening, or if you're working with attorneys on your cases, ensure that you're asking them if they're doing that deep dive, in a place like Presidium Investigations. That's someone that can really help you to go through and find all that information.
And especially, that's when we look to these experts like Aaron and his colleagues to come forward. Aaron, as you know, I'm sure you've testified many times, they have to go through this blistering cross-examination, which is very key, which is why the selection of experts is so key. And looking at the outdated defenses, forget the statute of limitations. There's that legislation has passed. We don't have statute of limitations, so that's out. The age of consent is out. It changes jurisdiction by jurisdiction. You look at some states, the age of consent is 16. The age of consent in New Jersey is 18. Age of consent in New York is 17. It varies across the state. It doesn't matter. All of these ages of consent doesn't matter because the legislation that flows from the Child Victims Act, for instance, says it's 18 or under. So the defense, and by the way, Misty and I've litigated this, some of the defense bar had said, well, the age of consent is 16. Therefore, there wasn't victimization of this individual. That does not hold water. The statutes itself, these local statutes that are populated throughout the country, the Child Victims Act being one of them, those statutes have upheld the constitutional muster to say that, yes, there might be an inconsistency in the law because you have one act that says at 18 or under is victimization, and you have the age of consent, which is 16, 17, wherever, where it can be in these jurisdictions. The courts upheld the Victimization Act with respect to the age. So those are outdated. And looking at the monetary awards, and Aaron mentioned some of them, we've talked about them, the $2.7 billion for Boys of America alone, $500 million for the Rockville Center Archdiocese, tremendous. These awards are getting bigger and bigger. And even if you're exactly right, Aaron, these are all settled. They're pretty much all settled. Most cases settle when you talk about these types of allegations. They settle in about 98% of the range. Only about 2% actually go to trial. We all know that when you go to trial, you are putting your case and your defense in the hands of 8 strangers. And these are such incredibly sensitive, polarizing, devastating types of allegations. We know because we have the gamut. We have children that claim they're being abused present day. We have adults claiming that they were victimized decades ago. The cross-examination remains the same. You have to be such a highly skilled litigator to show empathy, compassion, but still get your points across, regardless. that jury will look at these individuals and say, this victimization is so extreme. It's no wonder that so many of these cases result in the claimants and the plaintiffs' favor.
Yeah, and so you see a lot of these cases as we go through the discovery process and we have depositions, and many of them go to mediation. And when you have a child, so as Mercedes said, different types of cases, sometimes we have adults who claim that they were sexually abused in the past. Sometimes we have children who claim they were sexually abused not too long ago, just the amount of time it takes to go through state court. And when you have those types of severe allegations, of course, that increase in monetary award piece, you see clients wanting to settle those cases as opposed to having the child go into the courtroom and testify before the jury and have issues with impeachment of their testimony. And not only that, there's now this movement, and the plaintiff's bar is using this, especially in New York, with children who are victims of abuse. They're talking about re-traumatization, and they're trying to limit what we can do and the questions that we can ask to these children who have alleged abuse, because even the act of being deposed or the act of having to relive this over and over again can be re-traumatizing. And we're seeing that being tacked on to damages analysis by the plaintiff's bar. So that increased monetary award can actually be problematic just from a litigation point of view as we work our way through these cases.
And it's really ironic because many people would say, well, if you have the child witness and plaintiff, that really is going to stir the emotions of that jury. It's actually sort of converse, because you have these adults who have this allegations of severe trauma decades ago, but they have all that empirical data that shows how that actually affected their lives. Failed marriages, alcohol abuse, drug abuse, can't maintain jobs. So when you have a child plaintiff, that all you have are experts saying, well, this is what we believe their life will become and be like, so therefore the monetary awards have to be that much greater. But it's actually reversed. You have these adults, if they are able to actually succeed with their allegations, those awards are tremendous. So it's actually converse, because you would think it's really going to be the child that's really going to hit the jurors and get these enormous awards. It's actually the converse. Standards and centralization, Misty, that is such a big issue. And this is what a lot of our clients struggle with, because they are dealing with standards from decades ago that didn't have the same strict compliance that exists present day. But no matter, they still have to comply with what occurred today.
Right. So looking at the Child Victims Act, you're talking about cases that happened 50 years ago sometime, really, really far in the past. And those standards were not in place at the time. And now these cases are being litigated under today's standards. So it can be incredibly problematic from a defense perspective, especially when we're in a situation where we're litigating cases where there wasn't electronic record keeping. We're litigating cases where records have been destroyed years and years ago. We're litigating cases where the alleged perpetrator is no longer alive in many of these cases. So there's a lot of issues with applying the standards of today to older cases, but that's what we're dealing with as we litigate these cases. In addition to that, there are more tangible increasing standards and centralization. For instance, let's look at the evolution of Title IX in schools. Now, Title IX requires a specific office just to deal with these types of claims, specific, centralized, and requirements in order to be compliant with how the investigation proceeds and how all of that is determined internally. So there's one example. Another high-profile case or another situation, I should say, it's not a legal case at the moment that we've been watching, is legislation about Congregate Care Act. So this was brought to the attention by, surprisingly, it's Paris Hilton. She had a documentary relating to her experience at the Provost School in Utah and the child abuse that she said went on during that time. And now other people have been interviewed, and legislation has happened in Utah to require more transparency in the rules and regulations and investigations, and providing that information to both law enforcement and to the parents when there are allegations of abuse. Well, Actually, now this issue is being looked at on the federal level. So as Aaron was talking about, some of the most vulnerable populations could be susceptible to this type of abuse. So what do we do to try and avoid that from ever happening and have the right protocols in place? Well, to some degree, companies are learning from litigation and backtracking and plugging up the holes. But in other cases, there's an evolution of rules and regulations that they're required to meet in addition to creating their own internal procedures.
There is, and that very last part that we want to go before the next slide, we had 2 cases that were going to trial during COVID. The COVID post, we're still in COVID, but the COVID jurors are very, very different. Your Gen Zers are now your juries. When we are working with our jury experts, because we had mock trials that we're putting together, we were obviously working with the experts as well. The juries now are looking for accountability. They're not just looking at the bad actor. They're looking at the board of directors. They're looking at the organization leaders. They are looking, especially the Gen Zers, as I've just mentioned, they're in that sweet spot, 18 to 24. They're looking for accountability at the very highest levels, and they're stealth. You don't know that that is their predisposition. Then they go into these deliberations and they're the lions and lionesses in that deliberating room and driving these enormous types of recoveries. Very dangerous for in this post-COVID world. Those 2 cases settled, but we had all this data that was developed by working with the experts. What are we talking about with respect to the causes of action? Aaron mentioned, of course, negligence claims come in. I love this graph because it shows, especially negligent supervision is the biggest one. Prevention, yes, obviously we all want to try to prevent these types of claims. But if it does occur, that's where there's this expansive scope to look for who's responsible. It will fall on the hands of, well, how did this occur? If adequate supervision was done, it would not have happened, which is why that's why the jurors look for negligent supervision will really ring the bell.
And inadequate security. Again, especially relating to cases involving children, inadequate security has been a really big aspect of the Child Victims Act cases that we're now litigating. So that's also something that we've had challenges, although through investigation and through doing our due diligence, because some of these places may have a third party who acted as a security guards at the time. And so there's a bit of a complicated structure there, but it's really important to make sure to dig into those types of issues as you're working through discovery.
I just want to say one very important point on that. And Mercedes and Misty are making a very, very, very cogent point that it's important to pay attention to, which is you're looking at your organization from a prevention perspective, from an investigative perspective, just like Aaron alluded to, and from a defense perspective. One of the key pieces to defense is, of course, if you have third-party vendors that are providing with security services, that are providing you with consultant services, it's important to make sure on the upfront level at the beginning that you're negotiating contracts with those outside vendors that are going to protect your organization in the event that they're not adhering to all the great principles that we're talking about today. They're not adhering to the appropriate steps and standards as far as prevention is concerned, as far as investigation is concerned. You can then, in that circumstance, you have the opportunity to do what we call risk transfer, which is to take those exposures and take those risks and move them away from your own portfolio of potential losses out somewhere else, out to these third parties who in theory may have breached their obligations to you to provide appropriate security services. That's where the partnership between defense counsel, your insurance consultants, and folks over Presidium can help you analyze those kinds of issues and really help you contain some of the costs related to insurance that we're going to be talking about in a few minutes.
That's such a great point, because all those hold harmless provisions, we look at the contract at the very beginning, and if there is a defense, a duty to defend, we actually have that letter sent to those third parties and they will pick up the defense. And one other thing, and that's such a great point, Josh, make sure that your insurance also, your clients, have the insurance in place by these third parties. Where they're an added insurer.
Absolutely. And the critical, the mission statement, the critical thing to keep in mind is you obviously need to make sure that those contracts are ironclad before you engage in service. You want to make sure that you have the right indemnification, hold harmless insurance requirements, and that you're vetting the insurance of your various vendors and the third parties. If the insurance is inadequate, the fact that they're going to be protecting you with indemnification is not going to matter much.
Exactly. And one of and really you have all the cards at the table at the very inception of these relationships. So that's where the negotiation comes in. We've helped. Standard of care we've mentioned will vary decade to decade, year to year. Standard of care is dynamic, depending on what that particular establishment entity as a whole, not just at that one individual, but what is the standard in that particular space? What do they do? What are they doing? Are they using third parties? We always tell our clients, use third parties to come and do your investigations. They are the experts. The questions the investigators ask are so key. That becomes part of what the plaintiffs will ask. Well, what was asked of these? Well, these improper questions were asked. If you're not working with professionals like Presidium to do that type of investigation, it can really falter the defense of the case. And of course, the constitutionality of these types of acts that we mentioned have already passed muster. They're going to continue.
Yes, the CBA, that was challenged across the board when it came out most recently in the case against Prince Andrew by Virginia Giuffre. The federal court upheld the law and said it passes muster on the due process issues.
So we have a lot of statute of limitations reform. We know there's one in Vermont and Guam, and Missy, you're going to talk about that because they just eliminated statute of limitations.
Yep, they eliminated the statute of limitations, but the thing that makes it unique, because other states have also done that in the civil sector, is that they're also made the statute retroactive, and not many states did that. So that is just an opening the door to floodgates for these types of claims.
Are you folks seeing that what Guam has done, is there a possibility that this is going to gain momentum, that we may see further amendments, even in those states that have adopted or reconstituted statutes of limitations for a more narrow window? Is it possible that through critical mass, you're going to start to see further expansions on this kind?
It certainly is. And in fact, there's currently pending federal legislation, which is something that we have not seen yet on this front, because these statutes are largely state to state, but federal legislation talking about eliminating those windows for federal cases in sex abuse cases for over 12 different types of allegations. So certainly I think what we're seeing in Guam, we're going to continue to see the terrain change in the United States,
so,
and it perhaps on the federal level.
So really the bottom line is this, is that, going back to what Aaron was saying, every single time that you're looking to undertake an effort towards preventing these instances, every single time that you're looking to investigate a potential instance, you need to understand really that this is all evergreen. That what you're doing today, there's not going to be a window that closes on this. Right. It's possible that you're going to face litigation, you're going to face exposure related to that years and years and years down the line.
And that's exactly, I think the legislators have really put that into place, that this is going to be much more expensive than what we see today.
Yes, and to your point, Mercedes, we're talking about children and the Child Victims Act, because that's something we're dealing with day to day, over 10,000 cases filed just in New York. But the Adult Victims Act in New York is pending legislation. So now that opens the window to adults who are abused over the age of 18. So if that legislation is passed, we would expect to see an influx of claims. In fact, we handled a case where it was a demands letter, and the plaintiff's attorney brought up the Adult Victims Act, saying, well, it's almost inevitable that this will be passed. We were able to get rid of it for now, but there's a pin in it if this legislation actually goes through.
So what's really critical, all of these that we've listed, the hiring practice is absolutely key. The due diligence that's done with these individuals are hired. As Aaron said, you have to do very deep dives on these individuals that are brought in. Use a third party to do so, and I think Josh makes a phenomenal point. Make sure that you've got the right contracts in place, and in case they falter in any way, you're able to defer the risk. Witness statements, obviously very critical. Make sure when the investigations are done that those are reported. If this is decades ago, none of that's reported, obviously that's a different game, but these are when you are able to have these types of investigations in place. Complaint procedures, do you have the right complaint procedure in place? If you see something, say something. This is when we do this type of training for our clients around the country. We say that all the time. Any suspicious behavior reported, even if it's wrong. Maybe if you just saw it, interpreted it inappropriately, didn't understand, doesn't matter. Report it. Make sure that the authorities involved. Because authorities are very critical to the defense of the case. And
keep in mind that in some cases, for instance, schools, foster care agencies, there's already built-in reporting requirements of when this needs to be escalated to law enforcement. So it's something you need to be keenly aware of.
And training, obviously, which is what Sterling is doing for you, which is absolutely key to do.
Yes, agreed.
So, of course, especially with the Child Victims Act, there's a lot of hurdles in litigation, which is why investigation is so critically important. Here in New York, all of the cases have been centralized into one part, and something that is potentially problematic from a defense point of view is that the court is allowing information that has been received through discovery on one case to be used in other cases if there's multiple cases being brought against one entity. So that's unusual, and that's different from the typical litigation structure.
Just the last point before we turn to Josh and Susan, it really is that the fact, besides the legislation, there's a big push in the next slide that the judiciary pushes for all these cases to settle. Well, all of these cases, for the most part, not all, but there's a very large percentage of them are all being litigated in state court, not in federal court. These are judges that are elected. There's a lot of underlying pressure for these judges to really push for these high recoveries for the claimants and the plaintiffs involved.
Yes, and just quickly, the court is allowing under these rules, they've specifically trained judges to handle the CBA cases, and they're allowing for stays in order to pursue mediation and settlement for 90 days. So it's something to look into on your cases.
Okay. Thank you so much. Okay, so thank you all for joining today. Thank you, Misty. Thank you, Mercedes. Excellent presentation. And thank you, Aaron. Unsurprisingly, I think that this is the most important part of the presentation. And there's a reason why. Because when you talk about prevention, investigation, and defense, those are the critical assets, the key levers that you're going to pull, the critical pieces you're going to deploy in order to contain all this risk that we're talking about today. The risk of abuse and molestation that is presented to your organization, not-for-profit, social service, human service. The only way you can contain that is through deploying all of these critical resources. Obviously, though, all of those resources require key financial commitment. So the question is, how are you going to finance all of those critical assets? And so what we're going to do over the next few minutes is talk about how do I build a comprehensive insurance program in order to finance deployment of those resources. The more resources that you can deploy, the better off your organization is going to be, because the more you're going to be able to contain that risk. And so how do we do that? Well, first, what we're going to do is we're going to take a step back and look at how traditional insurance operated in the abuse and molestation space for organizations just like yours, social service, human services, not-for-profit. Then we're going to fast forward and we're going to explain how over the last 20 years, the traditional kinds of insurance that would have responded to these exposures have effectively been eliminated. They've been eliminated because, as Mercedes, Misty, and Aaron alluded to earlier, as these verdicts have continued to mount, as insurance companies paid more and more money to indemnify these kinds of losses, the market became tremendously restricted. So what happened? The market's response was to build out what are called abuse and molestation insurance towers to fill those gaps. What we're going to then talk about is, okay, you've placed an abuse or molestation insurance tower. What do I need to do to avoid critical gaps in that insurance program? Because obviously, if there are critical gaps, that effective risk transfer, that financing of those resources is not going to be there for you. And finally, we're going to look at, and Susan's going to do an outstanding job of presenting to you, how do you bring your risk to the market so that you can make it the most attractive, so that you can get the most competitive premium with the most comprehensive terms on coverage. So we're going back again, taking a step back and looking at the historical structure for coverage for abuse and molestation claims in these kinds of business segments. And it worked through what's called traditionally a general liability insurance policy or an occurrence-based insurance policy. So let's use a hypothetical. A particular employee of your organization allegedly perpetrated abuse against a client, a patient, a resident. In that circumstance, almost certainly, the employee would not be entitled to coverage because the key trigger to traditional insurance was an occurrence, or what's called an accident. However, and obviously abuse in almost virtually every circumstance is non-accidental. However, the insured organization, on a theory of negligent hiring, supervision, what Aaron alluded to, what Misty and Mercedes alluded to, that was a claim that was almost certainly going to be covered under older policies. So what happened? Again, as these verdicts and these exposures and these payouts continue to mount, carriers in these particular business segments effectively eliminated coverage for these kinds of exposures by including all sorts of new coverage restrictions, most principally assault and battery or assault and molestation exclusions built into their general liability programs. They did not want to cover these risks, and they're not covered elsewhere. They're not going to be covered under employment practices liability insurance or directors and officers liability insurance. Those kinds of coverages have built-in bodily injury exclusions. It's not there. So what do you do to fill the void? Well, new products have come onto the market, assault and molestation insurance, that can fill that void for you. But, and there's the key but, and Susan, if you could go on to the next slide, please. There are gaps in these kinds of programs. And if you don't know what these gaps look like, you're going to end up with a major issue. And these gaps have evolved over the last few years because, as I said, as these payouts have increased, even assault and molestation insurers, carriers in this space have come up with new restrictions, new policy wordings that are in theory designed to drive down premium and cost, but you're exchanging something. As you get reduced premium, you end up with additional restrictions, and that can be a major problem. You need to be mindful of the gaps. The first gap that we're going to talk about is by far and away the most complicated, but as Susan and I have discussed many times, we see this coming to us from clients and from prospects and from policyholders outside of our organization constantly, and you need to be you need to pay very close attention to it, and pay close attention because it is a little bit complicated. In order to understand, we're again going to take kind of a step back in time, and we're going to talk about the key coverage triggers that exist on abuse and molestation insurance, that coverage that will not exclude abuse and molestation claims. The first kind of trigger is what's called an occurrence trigger. We talked about that a little bit earlier. In this context, it means the abuse has to take place during the policy period. If the abuse takes place during the policy period, the insurance company does not care when the lawsuit's filed. They don't care about that. They're going to potentially cover that claim. Claims made and reported abuse and molestation insurance is something totally different. They don't care about when the abuse took place. All they care about is when was the claim made. So using an example, if that claim is made, if the lawsuit's filed in 2022, a claims made and reported insurer does not care that the abuse took place back in 1985. They're going to cover that claim. Now, if you have primary insurance and then an excess or umbrella program that sits above your primary insurance, let's say your primary policy is $1 million and then you have $5 million in excess insurance over that $1 million. If all of those policies have occurrence-based trigger, you're good to go, you're okay. If they all have claims made and reported triggers, you're also good to go. You're generally speaking going to be okay. What's the problem? The problem is like in the movie Ghostbusters, when you start crossing the streams. If you start developing programs that have mixed triggers, you're going to end up with a major issue. And I'm going to use a hypothetical to illustrate how this all works, and pay careful attention because this is, again, a major point. Let's say the abuse took place in 2015. You placed a claims made and reported excess tower in 2022. And the primary policy that specifically listed primary policy in your excess program is an occurrence-based 2022 policy. What happens? You've got to make sure and understand those excess policies in 2022, which in theory should be implicated, right? Because that lawsuit was filed this year. They don't provide excess coverage to just any insurance policy. It has to be the primary policy specifically listed in those excess insurance contracts. What's the problem? The problem is that the primary policy that we're talking about is a 2002 primary occurrence policy. And the abuse didn't take place in 2022. Remember, it took place in 2015. So if that primary policy does not stroke a check for $1 million, that policy limit, those excess policies, those claims made excess policies will never be implicated. And you've got a major gap in coverage. We are seeing this constantly. Bottom line key takeaway, if you've got mixed triggers on your insurance program anywhere, you really must get in touch with us here at Sterling. We can help you navigate that issue. We can assist you in ascertaining or interpreting whether or not you do in fact have a coverage gap. Now, Susan, if you go to the next slide, we're going to talk about some of the other gaps. I will tell you that these are definitely not as complex. When we see them, they're equally prevalent. Remember, we talked a little bit earlier about the fact that employees in traditional insurance wouldn't have been entitled to coverage under a basic occurrence policy because abuse is in fact intentional, it's not accidental. Well, in the abuse and molestation insurance space, you can, believe it or not, get some form of sublimited coverage and or some form of defense-only coverage for your employees on your abuse and molestation insurance program. And that can be very valuable keep in mind, as Misty and Mercedes alluded to, and as Aaron alluded to as well, orchestrating a defense, the deck is already stacked against you. These are difficult cases to defend. If you can align interests with an employee, especially where you've done a great job, you follow all of Aaron's advice, you've investigated comprehensively, and you've determined the allegations are without merit. If you can't get insurance coverage for that employee, guess what? There's potentially an innocent actor there that you can coordinate defense with. That leads to more comprehensive and effective defense if everybody has insurance, because if that particular abuser or alleged abuser doesn't have insurance, they got to hire their own lawyer, and the odds are they're really not going to participate in defense of the claim. So get that coverage if you can. If you can flip it, Susan, to the next slide, please. Okay, we're talking about a couple of other issues that we see fairly frequently. Professional liability trigger. Your sexual assault and molestation, or your abuse and molestation coverage can be tethered in one of two ways, or really one of three ways. It can be tethered to your professional liability insurance. Let's say your organization provides medical services, social work services, dental services, whatever the case may be. If abuse and molestation insurance is pegged to the provision of professional services, what happens when a janitor commits the alleged abuse? Well, if a janitor commits the alleged abuse, that may not be professional in orientation. And if that's the case, you're missing half the coverage that you need. So you need to make sure that abuse and molestation insurance, your liability limits, are pegged to your full spectrum of services so that you're comprehensively protected. One of the other things that Mercedes and Misty alluded to or mentioned really extensively was this whole idea of the reinvigoration of statutes of limitations for stale, what were previously stale claims or older claims. Somebody was abused in 1985. In theory, your current policies going back to 1985 are going to be the ones that are on risk for those exposures. Those are the policies that you need to notice. But which organizations out there have records of policies that were in place 30, 40, or even 50 years ago? I deal with this issue constantly for clients. An ounce of prevention is worth a pound of cure, because if you don't provide timely notice, particularly here in New York and in some other jurisdictions such as Georgia, the clock is ticking on you notifying that insurance company of the lawsuit. And if it's an untimely notice, you will not have coverage for the claim. Get those policies listed and resourced and warehoused now, so that if and when a lawsuit comes in, you can immediately provide notice to your insurance companies. And guess what? There are outside resources that can help you with this. Your broker and insurance consultants should be able to help you with this. And we have access to insurance archaeologists here at Sterling that can help you recreate this entire coverage structure. It's a critical issue that you really need to be looking at. Finally, I want to talk a little bit about selection of counsel. So a best offense is always a good defense. Before you get in any claims, your abuse and molestation insurance coverage is, as Susan will tell you in a couple of seconds, it is subject to larger self-insured retentions, almost certainly. It's subject to to a number of different kinds of sublimits and other restrictions that actually give you more control over which law firms, which consultants, which outside experts that you can retain in connection with the loss. Start talking to your broker, start talking to your insurance consultants, your preferred panel counsel, your defense counsel, and your outside consultants such as Presidium now about getting your insurance companies to approve them before a claim even arises. If they agree to retention of all of those different outside vendors, using your broker as kind of the ringleader to bring this all together, it's going to lead to a more effective defense. It's going to lead to more effective prevention of abuse. It's going to lead to a more effective investigation of abuse. It's going to be the marshaling of all those resources through your insurance assets to give you the best possible outcome and to present you as the best possible risk to the marketplace. So with that, it's a perfect transition. I'm going to turn it over to Susan for the balance of the presentation. Thank you so much.
Thank you, Josh. I know we're running late, so welcome. For the past 10 years, as we've been mentioning, the insurance carriers have had increasing loss ratios as a result of the development of abuse claims. And what that results in is our insurance carriers have cut back on the number that's out there to provide coverage and the capacity. And for capacity, we mean that their limits have been reduced, their retentions are increasing, they're offering claims-made coverage more often, they're including defense within the limits. All of this is an additional cost, as most of you have seen over the past few years. So when we talk about insurance costs, we recognize that for you nonprofits and the social service business, that's taking away services that you can provide to your clients and others. So we want to be able to help you. And how do we do that? We want to get you the best in class providers so that you can make good decisions and be on top and get informed before renewal time. So at SterlingRisk, we start this process about 120 days before your renewal. And we go to the markets that we have market clout with, that we deal with. We have relationships, long-standing relationships with these underwriters, and we get you some market intelligence. We benchmark and we look at different ways that we can structure your retentions to best fit the needs of your organization. And a lot of times underwriters are very pleased when you're looking to take a retention because you're actually putting some skin in the game and they realize that you have a commitment also to exploring these things and helping you with your abuse. Traditionally, we communicate throughout that process so that you have a better understanding. But throughout the year, we want you to be really proactive. And by bringing in partners like Aaron and like Gordon Reese and others that can help you set up protocols, will set you apart from your other competitors and other people in the marketplace vying for those same limits with those underwriters. We want to make sure that you participate in claim reviews and that we can tell the story about if you've had incidences and what steps you've taken. And by making sure that we have loss control in place with your broker that can help guide you through it so that we don't have any repeat kind of claim scenarios. We also, let's see what else. We review your contracts and make sure your protocols with the outside vendors, as Josh alluded to, are clean and that they have the proper risk transfer and that anybody that's coming into your operations has the proper protocols and background checks that you need so that you're comfortable, that cameras are in place. All these things make a difference. And what we're here to do is to position you so that when we bring you to the market and to bring you to the underwriters, that they understand your commitment to making this a mutually beneficial relationship. So really, that's our key here.
Absolutely, absolutely. Okay.
Thanks.
So I think that wraps us up. We're going to take a look to see. Thank you so much to everybody for participating today. We greatly appreciate it. We do have some questions. We realize we're running a little bit late on time, but we do, of course, we did start a little bit late. So I apologize about that, but I'm going to take a look. We're going to pull up the questions right now and see and see what we have here. Now I'm blind as a bat, so if anybody here can see.
Yeah, I
The last one, right? It's the only one that's asked a question. Oh, good morning. Will there be materials or handouts made available to participants in this presentation? I'm confused. Claims made policies all have retro dates that do care about when the abuse took place.
Okay, so those are actually two really good questions. We'll start with the administrative one. The PowerPoint, the presentation, it's all been recorded and it will be available after the fact. As far as retro dates are concerned on claims made structures, that is true in certain circumstances. The issue is that especially in circumstances where you're moving or transitioning between occurrence and claims made or claims made to occurrence, retro limitations will still leave you with that gap. And it's navigating those issues. And what I said before about contacting and having a conversation about those mixed triggers, that's where you really need to be mindful of, well, what do we need to do in terms of exploring what our retro limitations look like to see if that gap is there, usually it is, and the extent or the nature of how that gap might ultimately present. But that is a very good point. It's a point that you definitely need to consider when you're looking at where your coverage is going to be available to you when you're mixing those occurrence versus claims made triggers. Listen, in some circumstances, what you're going to do, using my hypothetical again, if it's a 2015 occurrence loss, hopefully you have coverage that's occurrence that sits above the occurrence tower back from 2015, using that factual scenario again. We have found that is definitely not always the case, and especially that we have found that it's not always the case when the problem perpetuates itself. We've seen circumstances and situations where there have been 5 years worth of mixed triggers on policies rolling over and over again. You're going to have that potential gap. That's a very good point. claims made over claims made, you're not going to usually have that problem, especially when you get a retro limitation that goes back as far as possible. But yes, very good point. I don't see, okay. So I don't see any other questions here. I want to thank everybody for joining us today. Everybody's contact information is available in the PowerPoint. The PowerPoint will be linked to our SterlingRisk portals here on our website. We're going to be distributing it to all the participants in the webinar today as well. Thank you again. Have a wonderful day, and we really appreciate your time.
Hey, Josh, there were 2 other questions if you have time to answer those.
Oh, of course,
Oh, I
absolutely.
see,
No,
yeah.
they're not popping up for some reason. Okay, go ahead.
The first question is, what is negligent retention, and can you provide examples?
Okay,
Yeah,
you guys go ahead.
So essentially, negligent retention is when you either know or should have known that this person posed a danger to your organization, to those individuals within your organization, either employees or patients, adult children, whatever it is. But now you have notice of this problem, but yet you allow this person to continue in your employment. And that is particularly dangerous for organizations. We see it time and time again. If you have a problem employee, certainly one that's exhibiting the warning signs that we've all talked about here, that someone has to be disciplined and up to including removal from the organization.
Yeah, so and also sometimes something from someone's past can come to light during their employment, and to the extent that there are complaints, it's absolutely critical that it is investigated thoroughly, because the negligent retention issue can actually roll into a negligent investigation issue, can actually roll into a negligent employment issue. So it really goes hand in hand with all of those issues. And again, going back to the importance of background checks of your employees, especially in these types of situations.
And document.
And document.
And
yeah.
document it. I mean, we see this all
Correct.
the time, and I can tell you that when we're developing risk control plans with our clients, you'd be surprised how many have robust investigative procedures, and for whatever reason, either they're not following them,
Right.
or they haven't documented it appropriately. So that's definitely a huge trick of the trade as well.
One of the issues we see play out quite frequently related to negligent retention is you have an employee or volunteer who exhibits red flag behaviors that aren't raised to the level of suspected abuse, and they don't exhibit them every day. They exhibit them every 3 months, every 6 months, every year. And what happens is it's red flag behavior, no response, red flag behavior, no response, red flag behavior, no response, and then abuse. And so then a plaintiff's attorney will come out and say, you were warned here, you were warned here, warned here, your response was nothing, nothing, nothing. That was a foreseeable incident. And so if there's no progression in discipline for that employee, meaning, oh, we wrote him up, or we retrained them, or we fired them, but obviously there wouldn't be a negligent retention if we did that, then an organization can be found to be negligent in the retention of that employee or volunteer, or youth for that matter.
I'm sorry. Yes, and something to combat that is training your employees, your managers, to identify those red flag issues. So even if a specific complaint doesn't come in,
Yep.
there's somebody who's keeping their eye on that, so it can be investigated and looked into by the appropriate people
Yep.
within a company. Now, those types of procedures are in place for schools and other organizations, but private industry may have to create that in their own protocols and go have that training in addition to the other trainings that you have.
Right. And just something also to keep in mind, again, turning it back to the coverage issue for a minute, there is case law out there, depending on which jurisdiction that you're in. The more you know, like Aaron was just alluding to, the more prior knowledge that you have of a problem employee on those older traditional occurrence policies, if they're implicated, if there's really this material, robust knowledge of prior conduct or ongoing conduct, we have seen carriers that have tried to say that doesn't even fall into the definition of accident or occurrence for the insured organization.
Right.
So you may have a theory of negligent hiring, negligent retention, negligent supervision, but when those facts kind of spill over into what they consider to be almost borderline reckless / intentional conduct, you may not even have insurance for those older claims. So it's really something to keep a very, very, very careful eye on.
I love the second question regarding compassion. How does I'm sorry affect any potential defense? It's a tightrope. And I think that's a great question. It is absolutely a tightrope. They have to show compassion, because that's where these punitive damages flow in. The callousness in which the claimant, the victims, the purported victims were treated, that's going to be problematic. So how do you show compassion? I'm sorry that you feel your experiences have been. It's almost like I'm sorry. It's not I'm sorry for your experiences. I'm sorry you're feeling your experiences have been. So there's no implicit admission that wrongdoing has taken place. But it is absolutely a tightrope. That's why it's so critical to get a third party in to do these types of investigations and really leave it to the expert to do it. They know how to navigate that tightrope. That's why Presidium is so critical to this equation to prevent these types of.
Without,
When you look at the organizations who have been held responsible for these incidents, and a lot of this may be more current day incidents, but not solely, is the organizations aren't being sued because of the incident. They're often being sued because of their response to the incident and their perceived reputation within the community. And that's a bit of a different issue, but it's all combined. And so what I mean by that is when victims come forward, if they feel like they're stonewalled, they feel like that there's no compassion on the other side, that's when they start to go to the press. That's when they start to go to plaintiff's attorneys.
Exactly.
And so it is a tightrope, and not every situation is responded to the exact same way. So we don't always say apologize. We don't always say X, but the general principle is that we want to show compassion so they know we care.
yes.
And then consult with an expert in terms of how to do that. But yeah.
Right. And when we talk about consulting with experts, by the way, it really is kind of like a tripartite relationship. You're going to have your outside counsel that's going to be helping you navigate those issues. You're going to have your presidiums and Aaron to help you navigate those issues. When you're talking to your insurance consultants about these things, keep in mind admissions of liability, admissions of fault, attempts to settle claims. Those can be very big problems when you're dealing with an insurance claim. There are contractual conditions that are built into your insurance products that require you to let your insurance company know about a potential liability event, to let them know about claims, but you also cannot admit liability. If you admit liability in some fashion, that can actually prejudice your right to coverage under those policies. So it's really important to marshal all those assets to help you navigate the field of investigation, prevention, defense, and insurance.
Oh, there's another one. What if the organization is on a shoestring or deficit budget just to operate? How can an organization afford insurance, prevention, et cetera, when the organization can't afford outside investigators or consultants?
That's a very interesting question.
That's a
So,
great question.
I think, I don't know if Susan, if you have some thoughts on this, but I think that this is not a zero-sum game, right? Which basically means that there are going to be resources that you can look to, resources that you can deploy in terms of negotiating out an insurance product. There are, broader coverages out there. There are narrower coverages out there. Obviously, those of you that are in the non-for-profit space and social service, every dollar matters. If you're working with the right insurance consultants, ideally, they're going to be able to get you appropriate coverage on the best possible terms. They're also going to be in a position to help you by deploying some of these resources through library, right? Deploying some of these resources for you on a more general basis beyond just consultative or specific consultative approaches and formats. That can cost less. I would never assume I can't afford this, so I shouldn't really look into it. You should look at all the different complexities and variables that you can bring to play in order to get the best possible risk mitigation plan that you have. That's in your budget.
Agreed. And I think the insurance partners that you pick, as well as your broker and your carrier, offers extensive libraries, extensive videos, and training that's available to you, included in the premiums that are charged. So it's something that is definitely something that you need to look into.
Great point. Well, okay, I think that wraps it up. Thank you all so much for those of you that stayed for the questions afterwards, after the time allotted. We really appreciate your patience and your attention. Contact information again is in the PowerPoint in the webinar. Feel free to contact any of us with any questions that you may have. Have a wonderful day.